while we're waiting, my name is Rakim Brooks, President of Alliance for Justice. Thank you so much for coming out tonight. I feel like a genuine talk show host right now. It's just like, and so to start the night off, we're going to receive some welcome remarks from our host, Deepak Gupta, who leads the law firm Gupta Wessler, who's responsible for this really beautiful space. Not the weather, though I wish he was responsible for that too, but at least the space. There. Let's see if that works for you.
Hi, everyone.
Can you hear me? Not yet. I think they're managing it back there.
Okay. Now?
Yeah.
All right. I am a member of the Board of Directors of the Alliance for Justice. For those who don't know, it is a fantastic organization that is an organization of organizations of progressive groups, and they work on judicial selection, and they also help progressive organizations stay within the tax code when they're engaging in advocacy, which is crucially important. So they're a kind of organization that supports the infrastructure of progressive advocacy. I'm also a principal at the Gupta Wessler firm, where you are right now. And we're a law firm that focuses on Supreme Court, appellate, and complex litigation on behalf of plaintiffs and public interest clients. And it's great to be able to host you here at our space. This is the second time we're hosting an event with Alliance for Justice here. And the weather, this is just not characteristic of DC around this time of year, and it's really fantastic. So this event is part of a series that Alliance for Justice has called Holding Court, Justice Conversations. And the event today is to mark the opening of the new Supreme Court term. We've got some great featured speakers, elected leaders. We've got a panel to discuss cases on the upcoming Supreme Court docket and the implications for our rights and freedoms. So I'll stop there and turn it over to the other speakers.
Thanks, Deepak. Really appreciate that. So as always with nights like these, you have to give shout outs to the people who helped prepare and make this sort of excellent event happen. So Abby, I'm not sure where you are, somewhere around. Abby and Mahuk were two folks who helped to, oh, they're back there. Okay, come on, come forward. You know, people got to see exactly who's responsible for pulling all this together. So please give them a round of applause. One of our staff members, Lizzie, is back there. Plenty of Alliance for Justice staff members are around. Too many to name. There's Lizzie. Please thank her for all this hard work. She's kept me on track. As Deepak said, the Alliance for Justice is an organization that's been around for more than 40 years. I'm the second executive director, just coming up on my second anniversary, which has been fun. And our commitment is to building power among the progressive community for the purposes of transforming courts into the citadels of justice that we know that they should be. Hey, Tom, I didn't know you were coming. Nice to see you. Tonight's panel, everybody got a drink because you know it's about the Supreme Court, right? I mean, you all are a strange crowd to have come to a preview of the Supreme Court knowing what they've done in the past few years, but we're lucky to have really excellent experts on a variety of the cases that are going to be presented, and so I want to share that with you. And again, thank you for spending this time with us. But before we get started, in terms of the panel, we've got some really excellent guests. First, Congresswoman Deborah Ross, who's joined us from North Carolina. For those of you who know our work intimately, you know that we have a slogan that we've begun to try to popularize. You need movement lawyers to become movement judges to create movement law. And so we're really proud to have Deborah Ross here because she was a movement lawyer. She was a civil rights attorney before she became a member of Congress. She now serves as the vice-ranking member of the Judiciary Committee and also is part of the Democratic leadership team. And so we thought there'd be no more fitting person to kick us off than the Congresswoman. So please.
And I have real written remarks. Well, it is great to see everybody here. And the best part was I walk in the door and I see a friend from Raleigh, North Carolina, who's now working for Equality Federation, who the ACLU, I was the executive director and legal director of the ACLU in the 90s, right during the contract on America. And one of the young people who was then advocating for LGBT rights, because we didn't even get to tea at that point. And he's now representing Equality Federation, Ian Palmquist, who's here. And so it just really warms my heart that everywhere you go, the people who have been doing the right things for the right reasons are still fighting the fight. As we're less than 2 weeks away from the Supreme Court starting its next term, this series provides a great forum to not only discuss the cases we expect to hear, but reflect a bit on the cases from last term. And in the past few terms, we've seen disappointing and frustrating decisions from a conservative majority on the court, but we've also seen a few glimmers of hope. The thing that's been most disturbing is that we've seen a willingness to overturn long-standing precedent and ignore basic ethical standards. One of the first bills that I got signed into law as a freshman member of Congress last term, bipartisan bill, was the courthouse ethics bill that required federal judges to disclose in real time their financial holdings. After that, many federal judges had to recuse themselves from cases that they had sat on for years. This session with Senator Wyden, I have a bill that will prevent judge shopping, as we saw in the Mifepristone case, where you could go and find a judge who you know will already agree with your position and have them be the sole fact finder. And so it would create a 3-judge panel of fact finding, much like we have in redistricting, so that you couldn't have just one hand-selected judge. We hope that bill will move forward. I think in the House it has less of a chance, but we're ready for 2024. One of the cases where we saw conservative justices overturning decades of legal precedent was in Students for Fair Admissions versus UNC and Harvard. This case was near and dear to my heart. I mean, here we had, affirmative action in decision-making for bringing students in to a university. The University of North Carolina didn't even integrate its student population until a generation ago. So they were clearly in a remedial role. I think Justice Brown Jackson's dissent in that case really put a fine point on it. She had to recuse herself, of course, from the Harvard case because she was an alum. But when she talked about what happened in my home state of North Carolina and the remedial measures that really have not even gotten us where we needed to go based on the history of our state, and the fact that even having those kinds of measures would be overturned and disregarded by the Supreme Court, shows us where this court is in terms of addressing racial equality in education. And then in 303 Creative, we saw the court got important protections for LGBTQ plus couples when they didn't really even have somebody who was challenging it. I'm sure you all read about the procedural machinations that we saw there. We also saw some important victories in voting rights last term, including in Allen versus Milligan and Moore versus Harper. Moore versus Harper was brought to our nation's highest court by the Republicans in my home state, who, by the way, still don't have a budget and are marrying casinos and Medicaid in the budget. But they wanted to put forward a fringe legal theory, and thankfully the justices saw that the independent state legislature theory was extreme and antithetical to the fundamental separation of powers in our democracy, which has freed individual state Supreme Courts to recognize that partisan gerrymandering is a threat to our democracy. But today we're looking ahead to the court's next term, and we already see a packed docket, including U.S. v. Romney, which will examine critical gun safety laws, which you know, of course, have to deal with people who are prohibited from having firearms if they have a domestic violence protective order, and the Consumer Financial Protection Bureau versus Community Financial Services Association of America, with arguments that will be heard in the very first week of the term and will question the constitutionality of the CFPB's funding. From the Dobbs decision to cutting environmental protections, the conservative majority on the court, I wish it was the minority, has proved that they're willing to ignore precedent and roll back our rights. As these cases come before the court, we are reminded of the importance of judicial reform and the need to adopt and abide by ethical standards. Our nation's highest court should be held to the highest ethical standards. If every other federal judge, member of Congress, and senior level executive branch official is subject to a code of conduct, the Supreme Court should be as well. Our democracy was founded on the promise of a fair, impartial, and independent judicial system. This means that judges will set aside any bias when they put on the robe and make decisions based on the facts rather than their personal opinion. That's why I've supported and advocated for the Supreme Court Ethics, Transparency, and Recusal Act. This bill would require Supreme Court justices to follow an enforceable code of ethics. Thank you. Almost done. The Supreme Court has had time to regulate and monitor itself. But as recent headlines and decisions show, the justices have simply failed to do this. And since the Supreme Court has not acted, Congress must act. As we watch this next term unfold, we must continue to press the court to uphold the highest ethical standards to ensure that we restore faith and confidence in the promise of an independent judiciary. I really appreciate the opportunity to be with you tonight. I know you're going to be just dazzled by the newest member of the Judiciary Committee, Becca Balint, who has brought so much energy, integrity, and spirit, not just to our committee, but to Congress. Thank you so much, and enjoy the evening.
Thank you so much, Congresswoman Ross. Congressman Balint, I think you're up. You've been properly introduced. And everybody see these shoes? Just so you know, if you missed them, Congressman Balint, yeah, show them off, please do. Congresswoman Balint is representing
Always business on top, party on the feet.
the at-large district of Vermont, is the first woman to do so and the first member of the LGBTQ community to also represent Vermont, which also deserves a round of applause. Thank you for serving. Thank you for serving on the Judiciary Committee, and we look forward to your remarks.
Thank you. So, full disclosure, I'm not an attorney, but I am married to one. So I feel like maybe you guys will let me in the club just a little bit. I'm genuinely excited to be here, and not in that way that members of Congress say, I'm so excited to be here. I really am excited to be here, and I'll tell you why. It's not just the topic that we're talking about that's near and dear to my heart and my community, the LGBTQ community, which is under attack every single day in Congress, from committee to the floor to the way that they show up with their meanness of spirit and their fear-mongering. So I am very excited to be here to talk about the court and this moment that we're in. But I'm also just really excited to make a connection with all of you, because I know all of you at your organizations are trying desperately to push back against the darkness. We are in a very dark time, and I constantly seek out points of light in my own work to be able to literally get up every day and go into that building and do the work for the people. And I know we share this in common. You also are doing such important work. So I don't have to tell you, we're in the middle of a terrible backlash. Whenever we make progress, whenever we expand rights and liberties to people who should have had them to begin with, there is a backlash, and it's ugly. And as I said, there's a meanness of spirit. There is a dehumanizing, demonizing aspect of the work that we see in Congress right now. And I will say, I'm totally off topic here. I will tell you, we who do not call it out for what it is are complicit in it. And I was talking to, so I introduced a censorship motion against Marjorie Taylor Greene. Yeah, long overdue, right? Long overdue. It had 40 counts, 40. And we even had to pick and choose, okay? And a reporter from a reputable news source pulled me aside off of the floor and he said, well, isn't this just a tit for tat? They censured Adam Schiff, and now you're censuring Marjorie Taylor Greene. I said, well, no, because Adam Schiff was doing the job he was called to do to protect the democracy, and Marjorie Taylor Greene is only about one thing and one thing only, and that is about Marjorie Taylor Greene. And when we don't call it for what it is, we are complicit. And he said, well, and I said, how long have you been covering the Hill? And he said, 30 plus years. And I said, have you ever seen it like this before? Have you ever seen this level of dysfunction and dehumanizing? And he said, well, no. I said, why aren't you reporting on it like that? Why do you keep acting as if it is a tit for tat, or it's, you know, he said, she said, or whataboutism? I said, I introduced it so I'm not complicit in the silence, and you also have a job to do. So that's what, I didn't anticipate talking about that, but I want to just like plant a flag here. I am the first woman to represent Vermont in Congress. I'm the first queer person to represent Vermont in Congress. I was the first woman and the first queer person to ever be the Senate president in Vermont. Think about that. So I know what it is to be a first. I know what it is to try to push against a system that is not actually hoping that you'll succeed. So there are so many dark things that we could talk about, but what I want to talk about tonight is actually punching through the darkness, poking a hole in this shroud that many of us feel in the work that we're doing right now. And the reason why I'm still hopeful, even though it is so dark and so many rights are being rolled back and we have a court we can't trust, is that before I was in politics, was a middle school teacher. That should tell you a lot about who I am and the kind of things I find funny. My wife also says I have a middle school appetite. But it is something that is deep in me. And I mention it because you cannot teach middle school unless you believe in the possibility of change. You just can't. Every single day, you got to get up with the sense of, I can help make these people into the people they most want to be, okay? So I believe, even in this darkness, that we can make real change still, and we must make real change. Now, coupled with my deep sense of hope, which I carry with me with fierce protectiveness, I know about the starkness of this moment, and I know you'll hear about it from Congressman Raskin, one of my personal heroes who will be talking later. Our democracy is in danger. It's not hyperbole. And it is very uncomfortable for me to say that and admit that. It is more terrifying to see it up close, in person, on the floor of the House and in committee. So we all have to put up the fight of our lives right now and not turn away and not be complicit, to protect our freedoms, to protect our communities, and to protect all Americans. This is the thing that I bring up constantly in committee when they're attacking my community. I say, where is the humanity? You are attacking Americans. We have to get back to that sense of moral righteousness and not shy away from it and not allow it to continue unchecked. So the other thing I wanted to talk to you about is I'm hopeful because I came in with an incredible group of freshman legislators. We were all incredibly impacted by January 6th. We were the people who saw the fire and ran towards the fire. And this has bonded us. We are a group that understands that the politics within the caucus are not as important as the focus we must have on saving the democracy. That gives me hope. The other thing that drives me is that my grandfather was killed in the Holocaust. And I have often thought, how would I show up at a time when rights are being eroded, when norms are being upended, when people are being scapegoated? And my parents instilled in me at a very young age, we do not take our constitutional rights for granted. We protect them with a ferocity. We must be absolutely vigilant. And that is what also drives me in my work. There are people I serve with who do not believe in democracy. They show it day in and day out. They do not believe in the Constitution. They show that day in and day out. And that's what I'm talking about. This normalization, oh, it's a fight between the Democrats and the Republicans. It's not. It's a fight between people who fiercely believe in this democracy and people who don't care if we slide towards a fascist government here, as long as they get theirs. That's what the stakes are. Now, I learned something the other day that I want to share with you because we all need hope and we need light in this time. You're doing work that's incredibly important, that's critical to the constituencies you represent, to the democracy itself, and to those of us on the inside who are trying to do good work. And it's this. The science has shown in the last few years that we physiologically, emotionally are impacted when we experience a sense of awe. It can be measured, what happens. And so awe can come from seeing this scene out here, right? This beautiful night we have. It can be through spirituality. It can be through singing with friends or dancing or seeing the great trees of Yosemite. That all elicits awe. And it changes us. It makes us better people. It makes us more open to different experiences. It makes us have more humility. But the most interesting thing that I learned was that globally, the thing that elicits the most awe is watching other people be courageous, watching other people expand what they think is possible. And so I'm calling on all of you to understand that you have a role in eliciting awe and inspiration in the people in your communities and in your colleagues. That is the only way that we are going to get through this dark moment, because the work will wear us down. And the question I always ask people when I meet them at events like this, and I ask some people here tonight, what is bringing you joy? We cannot fight this fight without continuing to replenish the well. So thank you for your invitation to be here tonight. It is the honor of my life to be in Congress. As a child of a working class mom and an immigrant dad, I never thought I'd be here. and I don't take any day for granted. So thank you so much for your time and attention. Really appreciate it.
I'm definitely in awe of Congressman Balint. Thank you so much. I didn't know we were going to church, but okay, I'm ready now. I'm ready now. I didn't know, no, but you know what? You came with the bedazzled shoes, and I should have figured it out, right? All right, well, slight change of program, but in the most positive way, Congressman Jamie Raskin, who also keeps us in awe, is with us now, representative from Maryland. And I have to say, as a courts lover and courts watcher, total fanboy, but in particular, because he probably had the greatest one-liner of the month when he talked about Supreme Court sugar daddies. And so I hope that makes it into the speech, Congressman Raskin.
All right. Well,
There should be a microphone there for you.
Hello, everybody. Thank you so much. Wow, this is a breathtaking view, isn't it? This is great. I assume this is not the Alliance for Justice's new office or anything. I am just very psyched to be here with my old friends from the Alliance and all the great freedom and democracy fighters here. And I thought that, God, it's a beautiful night, isn't it? Jeez, it's been rough down on the Hill. That's where I like to say it's not the heat, it's the stupidity. No, I wanted to, I know I'm here as a fierce, true blue, dyed-in-the-wool Democrat, but I know that the Alliance is a scrupulously nonpartisan 501c3 entity, so I thought I would start on a bipartisan note by invoking our last great Republican president, Abraham Lincoln, who spoke of government of the people, by the people, and for the people. And we didn't start with that beautiful, tantalizing vision when the country started. It was a slave republic of white male property owners over the age of 21. But it's been through successive waves of social and political struggle and constitutional change and legal struggle that we've come much closer to approximating Lincoln's beautiful vision. But the point I want to, I guess I want to make 2 points. And the first one, and I think it might sound very depressing at first, but I think I hope it is a point that will give you hope, is that the Supreme Court, for the vast majority of American history, has been a profoundly reactionary and conservative institution. If you think about the entire first century of our history, when we had the enslavement of human beings going on, the Supreme Court did absolutely nothing for the enslaved people other than to cement the system into place in the Dred Scott decision by constitutionalizing the whole regime of slavery and saying that the African American had no rights a white man was bound to respect, in articulating that the Constitution was a white man's compact that was designed for the purposes of perpetuating white supremacy. And then even after the Civil War, even after the Reconstruction Amendments in 1896 in Plessy v. Ferguson, the Supreme Court essentially cut the heart out of the 14th Amendment and the Equal Protection Clause by finding that Jim Crow apartheid was perfectly consistent with what the framers of the 14th Amendment wanted. The people who gave blood and sweat and tears, and hundreds of thousands of people died fighting for equal protection of the laws, and they basically read it out of the Constitution saying equal protection must be interpreted consistent with the customs, traditions, and usages of the people, by which they meant racism in the redeemed southern states. So when we think about the Supreme Court with a halo above it, the kind of Supreme Court that still inspires some people to go to law school, that court lasted for about 2 or 3 decades. It was around the time of the white primary line of cases in the late 40s and 50s. It was the Warren Court It was Miranda versus Arizona. It was Brown versus Board of Education. It was Roe versus Wade. It lasted for a few decades when the Supreme Court was on the side of the people. But it very quickly ended, even with respect to Brown versus Board of Education. Milliken versus Bradley said it only applied within a particular municipal district. It didn't apply to the suburbs. And then a whole train of other cases like that, basically drawing and quartering the Brown versus Board decision. So the Warren Court was followed by the Brown Court, the Rehnquist Court, and now the Roberts Court, which has been gerrymandered to perfection by Mitch McConnell and by the Federalist Society and the right wing. And they have retreated to the historic baseline of political white supremacy and class power and discrimination in the country. And we know they cut the heart out of the Voting Rights Act in Shelby County versus Holder. There's not much left of the Civil Rights Act. And so now everybody's looking depressed as hell, okay, as I tell this story. But what I want you to understand is look at the progress we've made despite the Supreme Court. Look at the progress that people have made through social and political movements in the country, because far more than William Rehnquist, long after Scalia and Alito and Roberts and Ms. Waterford, whatever her name is, long after these people are forgotten, okay, people will remember the heroes of the suffrage movement and the civil rights movement, the women's movement, the LGBTQ movement, the labor movement, the human rights movement, the peace movement, the civilizing movements of American history. And for a brief period, we had the Supreme Court on our side. I hope we're going to get the Supreme Court back. We're going to fight for a judiciary that's actually interested in the rights of the people. But regardless, we're moving forward. Right before I came over here, I had a delegation come visit me from the movement in Israel against their effort, against Netanyahu's effort to dismantle constitutional democracy, or they don't have constitutional, but to dismantle liberal democracy in Israel. And to ram through the Knesset a whole series of right-wing offensives against democracy and women's rights and LGBTQ rights. All over the world, the autocrats, the kleptocrats, the theocrats, the plutocrats are at war with democracy. And who's going to stop them? The Democrats are going to stop them, okay? At least the small d Democrats are going to stop them. And so, you know, sometimes a court can be on the side of freedom and democratic integrity. That's the people in Israel are fighting for a Supreme Court that's got integrity. We're fighting for a Supreme Court that's got integrity now too, but it's a court filled with right-wing judicial activists who are madly dismembering federal statutes, like the Civil Rights Act, like the National Labor Relations Act, like the Fair Labor Standards Act, and the Clean Air Act, and the Clean Water Act. So the common denominator in this struggle all over the world is a struggle for democratic freedom, for government as an instrument of the common good of the people, versus an idea of government as an instrument of private self-enrichment for the guy who gets in there and his family and the corporations who are aligned with them. And so I want to salute the Alliance for Justice and all of the groups that it works with, like People for American Way and the Leadership Conference and the Lawyers Committee for Civil Rights, that are fighting for a government that is responsive to the will of the people and fighting for the needs of the people, the interests of the people, and the rights of the people. And I'll leave you with the words of two great Democratic champions. One, the great Frederick Douglass, born about an hour away from here, maybe 50 minutes, on the Wye River Plantation, born into slavery, escaped from slavery, to become our great freedom fighter and abolitionist through the Civil War, through Reconstruction. And Douglass said, if there's no struggle, there's no progress. And the struggle may be moral, it may be physical, it may be moral and physical, but there must be struggle. Power concedes nothing without a demand. It never has, and it never will. There's a message to you from the people of Maryland and the great Frederick Douglass. And I'll leave you finally with the words of the great Tom Paine, you know, who came over from Europe in 1774, 2 years before our revolution. He fell in love with America. Fell in love with it. He said if America lived up to its vision and its ideals, it would become an asylum to humanity. Not an insane asylum, mind you, okay? An asylum to humanity, a place of a refuge for people seeking freedom from political and religious and economic oppression from all over the world. And in 1776, when the revolution broke out, and he had written Common Sense, which had helped to lead and precipitate the revolution, it was a tough time. And a lot of people said, you know what? Well, we've got a majority of the people on our side, but you fundamentally can't beat the autocrats and the theocrats. Most people, for most of history, have lived under people like Donald Trump and Vladimir Putin. That's been the basic fate of humanity. America was created on a different principle. We would try to move in another direction. We would separate church and state. We would grant rights to the people. We would have a principle of consent of the governed, democratic self-governed. And a lot of people thought it couldn't work. And a lot of people were running around, not unlike today, saying, we're not very good at messaging, and what's the message, and all that stuff. And, Paine wanted to give people some hope. And so he wrote this pamphlet called The Crisis. And I'm going to quote a little passage for you. I'm going to update the language just so it doesn't offend modern sensibilities. And Nancy Pelosi told me I had to do that, and Paine wouldn't mind because he was a feminist, and that he was. But he said, these are the times that try men and women's souls. The summer soldier and the sunshine patriot will shrink at this moment from the service of their cause and their country. But everyone that stands with us now will win the love and the favor and the affection of every man and every woman for all time. Tyranny, like hell, is not easily conquered, but we have this saving consolation. The more difficult the struggle, the more glorious in the end will be our victory. So let's make that victory ours. Let's take back the Supreme Court. Let's take back the government. Thank you, Alliance for Justice. Thank you for having me.
I'm sure our panelists are ready to say that's our show, folks. But we came here for a reason, to educate and inform. Yeah, that you can. So could I have the rest of the panelists join me up here, and I'll start introductions. Sam and Esther, and great. Sit in any order you'd like. While they're coming up, one more time, thank you to Congress members Ross, Balint, and Raskin for getting us started. I should have said at the outset that our Holding Court series happens recurringly, month over month, with different guests at different times, but this one is specially hosted by Gupta Wessler, Democracy Forward, and Earthjustice. Long-term partners. Oh, I'm sorry. Would you either close those doors or as they exit? Yeah, the Jamie Raskin fan club. Please don't flee. I'll say it one more time. Thank you for giving me the opportunity to once again thank our co-hosts, Gupta Wessler, of course, which Deepak introduced, Democracy Forward, and Earthjustice, among many others who have contributed to this event. They're long-term partners of ours interested in the fate of the courts, and so we're very thankful to them. I'm going to try to do a round of quick introductions because I know we're eager to get to the panel and wrap up the rest of the night. So first I'll start off with, again, our host, Deepak Gupta, who is one of our board members at the Alliance for Justice. He was characteristically humble. This court is a bad court. And yet many of the victories that we secure from the court comes at the hands of Gupta Wessler and the lawyers that work here, including Deepak. So they deserve a round of applause for the good things that they're able to do for us year over year. I'd like to also introduce to his right Esther Sanchez-Gomez, who is the litigation director for the Giffords Law Center. In that role, she develops affirmative litigation strategies to effectuate gun safety reforms and defends constitutional challenges to a variety of gun safety policies. Man, do we need you now. Thank you for taking on that important work. To her right is Sam Sankar. Sam is Earthjustice's Senior Vice President for Programs. He has been working on environmental issues throughout his career, including as a line attorney at the Justice Department's Environmental and Natural Resources Division. Sam, we're glad you could join us tonight as well. Last but not least, I think you've become a bit of a partner in crime, Joe. This is the second panel we're doing together. Joe Gaeta, he said, is pronounced like the guy ate a lot of pasta at dinner. So, so Joe is the Director of Oversight and Engagement at Democracy Forward. Most recently, he was Deputy Assistant Attorney General in the Department of Justice's Office of Legislative Affairs and previously served as a trial attorney in the Housing and Civil Rights Enforcement section of the Civil Rights Division of DOJ. I was also informed that he recently, as in this week, I guess, filed a lawsuit against Governor DeWine for his illegal takeover of the public school system. Oh, well, listen, we're gonna give Joe all of the credit for Democracy Forward's hard work in, again, securing our public school systems against government takeover. Joe Gaeta. So just a reminder that there are index cards and pins on your chairs. If you have questions, please feel free to write them down and pass them up to the front as we go along. I'll collect them and ask a few of the questions, and if there aren't any, we can take questions directly from the audience if you feel inspired later on. So, several important cases coming to the Supreme Court this year, as we understand, based on the past 2 terms with this court. They are on a mission. They have been planning for now over 40 years to overturn a woman's right to choose, which they achieved in the Dobbs case. They have been planning for over 40 years to reverse the gains that were due to affirmative action, which they secured in Students for Fair Admissions, and they're not going to stop yet. It's important that we be alert to what they're doing, the long history of the actions that they're taking, and so we brought up these experts specifically to help keep us attuned to exactly what's happening, the order in which it might happen, and how we might think about what it is they're doing. So again, as I said, you all came to this panel. We didn't thrust this on you. You know exactly the sad state of affairs that we have, but it's the state that what we've been given, and if we're going to fight back in the way that Congressman Raskin, Congresswoman Balint, and Congresswoman Ross suggested, we're going to have to stay informed. So with that, there are several cases that the Alliance for Justice is keeping focused on, and I thought I'd start with Sam, give you the opportunity to talk about Loper Bright Enterprises versus Ramato and the Chevron doctrine.
All right. Can anybody hear me? No? Louder. Okay. So first thing I want to do is get a time check and figure out how long we would, because you know me, I can talk about this for
why don't
45
we
minutes.
give you 2 minutes?
2 minutes is great.
Yeah. And then
So
we'll
how many
around.
people here have ever heard of the Chevron doctrine? Oh, all right. So it's a friendly audience. So the Chevron doctrine basically says, right, that when Congress writes a law about something and hands it off to an administrative agency to do good rulemaking and administer the law, the courts are supposed to pay attention to that agency, to listen to it carefully when the agency says, this is what the law means, and we've written regulations that interpret that law in certain ways. This, I have to tell you, is not always the environmentalist's friend. Many parts of the environmental movement are frustrated with the Chevron doctrine because when you have an agency like the U.S. Forest Service or the Department of Interior, pieces of the Department of Interior, that are captured by industry, often the deference is bad for the environmental movement because the agencies interpret things in ways we don't want. Congress gives broad laws, and they use them in the ways we wouldn't like them to do. So why are we worried about Chevron? Well, we're worried about Chevron because it is worried about this case because this case is not just about these regulations on fishing. It's about the enterprise of government in the United States. Administrative agencies are the way in which modern government gets done. Congress legislates with broad terms, make all the water clean, protect human health, and leaves it to the agencies to figure out exactly what that means and how to do it. So when the court says, we're not going to listen to the agencies, they're not protecting Congress, they're taking power for themselves. Because Congress has the power to correct agency actions. It can rewrite the laws, it can use oversight, it can decide who to confirm and not to confirm to those agency posts. Congress has the power to control those things, and guess who elects the president? Hopefully, the people. So executive branch agencies are under political control. There are strong systems for correcting policy misdeeds, misactions, wrong decisions by the administrative agencies. But when the Supreme Court steps in and says, We are the ones who read the laws, finally, for all time. There's no deference, there's no changing in this, and we don't listen to the expert agency. What they're doing is saying that the enterprise of government is not an enterprise of trying to get good policy outcomes. It's an enterprise of gotcha. And in the enterprise of gotcha, the industries are always going to win because they're always going to be able to find little cases like this where it doesn't quite make sense, and that's going to end up tearing down statutory regimes. So that's been the game that industries have been playing across the environmental spectrum, last term with the Clean Water Act, the term before that with the Clean Air Act. In each of these cases, taking down large sections of the law by finding ways in which it doesn't quite make sense in this one instance. So by removing administrative discretion and by taking for courts the primary power to figure out how policymaking should be done, cases like Loper-Bright and some of the other cases actually that we're going to talk about here today are part of an assault on the regulatory state. The right sees the regulatory state as a demon. I see it as the way we address climate change, the way we have safe drinking water for each other, the way we address air pollution and environmental injustice. Folks, that is the regulatory state. That is what the Supreme Court is coming after. That's why I'm concerned about an obscure case involving who pays for fees for observers on fishing vessels in New England looking for, fans of Monty Python, herring.
Thanks, Sam. Esther, let's turn to you with yet another case, United States versus Rahimi. It's not lost on anyone that this has been a year of seemingly consistent public violence, public gun-related violence. It seems to be increasing with every year, and that the people's representatives are doing their very best to rein in that gun violence through regulation, but now we get United States Rahimi. Why is this important?
Well, thanks everyone for having me. Rahimi is a really interesting case because it kind of sits at this intersection of the sort of law that everyone can agree on. And I don't just mean people in this room. I mean, if we were a room full of gun owners, of NRA card holders, we probably would all still agree that this law needs to exist. And it's coming at this moment where the Supreme Court has created this massive shift in what the Second Amendment looks like and in the way that the lower courts are dealing with the Second Amendment. And for those of you who haven't been following, I think it's worth just sort of backing up to last year. The Supreme Court issues its first decision in over a decade, completely changing the way that the lower courts address Second Amendment challenges. Instead of looking to tiers of scrutiny, and for all of my lawyers, that's the one that Rudy Giuliani couldn't remember about. So instead of doing it the way that we all sort of do constitutional law, we switched to this text, history, and tradition methodology, which the justices are calling originalism. You know, we can argue about that probably in a different moment. But basically, it asks lower courts to look to history to figure out if legislators have done something like this in the past. And so when we talk about Mr. Rahimi, who is subject to a domestic violence restraining order, it puts us in this interesting conundrum of what does it mean for legislators to have done something like this in the past, even assuming that we can take legislative action or inaction in the past to understand a constitutional right, which I think sort of defies logic in the first place. And so as this case is arriving at the Supreme Court, we're going to see how the court's logic sort of extends into this space. I was talking to my panelists earlier. I do think that there is some room for optimism in this case, but I think really what the long-lasting effects of this case is going to be is how the court reaches its decision in upholding this particular statute. When we interpret a constitutional right by looking to history, we've been having conversations here about, individual rights and expanding individual rights. The Second Amendment is sort of in the opposite space in the sorts of arguments that I'm making in my role with Giffords Law Center, right? I'm arguing that the Second Amendment needs to be reined in, but it needs to be reined in order to protect the other individual rights that we should be expanding, right? When we talk about domestic violence restraining orders in particular, we know that domestic violence is perpetuated primarily by men against women. So when we talk about constitutional rights, well, which constitutional right didn't exist when the Second Amendment was passed? Maybe the right for women to vote. So how do we interpret that in that context? And the Supreme Court will hopefully give us a little bit of guidance and hopefully not in the wrong direction. But that's really what's at stake here. And even if this law survives, bad reasoning in order to reach that decision could have bad effects for all of the other gun safety laws that are keeping us safe today, and the many more that we need in order to keep our community safe going forward.
Thank you for that. Joe, let's descend one circle further into the into Dante's Inferno. So another important case, the Consumer Financial Protection Bureau versus Community Financial Services Association of America, which is, oh my God.
A lot of letters.
Yes, a lot of
Yep.
letters, but but the Community Financial Services Association of America are the payday lenders.
Payday lenders.
Right? Okay, so good labels. Talk to us about this case, and in particular, if you could, just give us a history of quickly, of the constitutional assault on the CFPB, which has started from its very beginning and origins and has continued with some success, and so makes it one of the reasons we're really concerned about the outcome in this case.
Weren't we here just a couple of years ago talking
I
about
thought
that,
so.
whether the CFPB was constitutional and seal of law? So it's September, right? We're in divided government. We're in Washington, D.C. Who wants to talk about appropriations? Anybody? I'm going to talk about appropriations, but not with respect to an impeachment or how those might be tied together. But how, in this case, and you know, I'm a lawyer, I try to be prudent, I don't try to make big statements, but for the first time ever, a court has said that the appropriations clause prevents Congress from setting up an agency or a program the way it sees fit and funding it the way it sees fit. I mean, this is when we talk about unprecedented, the Fifth Circuit, this is an unprecedented argument coming out of the Fifth Circuit. So CFPB, seal of law, several years ago, was the kind of the culmination of an effort by regulated industry, the far right, the conservative legal movement, to find CFPB unconstitutional. Didn't quite kill the agency off, right? The court said that the director of CFPB, the removal provisions were unconstitutional, but if, you know, the remedy was the director can be, you know, fired by the president, and so that solved things. So CFPB still exists. It still exists today. The challenges haven't stopped, right? And this is now going back to the moment Dodd-Frank was passed. There's always in the background been this question of the not just is the director, you know, accountable and removable, but also the funding structure, is that constitutional? All that's left now is this question of whether the appropriations clause, which says very simply that no money can be expended out of the Treasury except subject to an appropriation passed by law, does that prohibit Congress from setting up an agency like CFPB that gets its money outside the appropriations process from fees on, you know, if it gets it from the Fed, and the Fed gets it from fees on banks? The court said, as a constitutional and separation of powers matter, the Fifth Circuit said, the Fifth Circuit. Let's not jump ahead. That the appropriations power is fundamental to Congress's ability to ensure that we have a transparent and accountable government. And so, because there's no CFPB isn't funded by appropriations, that's a constitutional problem. Now, here we are, September. We're barreling toward another government shutdown. So we've all lived through them before. So we sort of know, right, what is subject to appropriations and what's not. CFPB is going to continue to operate because it gets these independent funds. So do a lot of other bank regulators, the Office of Comptroller of Currency, FDIC. People are going to get their Social Security checks. They're going to get the Medicare benefits are going to continue to get paid. Those aren't appropriated from year to year. So when the Fifth Circuit says there's now this appropriations clause argument that limits what Congress can do, what is that? Like, that's a breathtaking argument. Does that mean that the Fed is unconstitutional? Does that mean that OCC is unconstitutional? Does it mean Medicare and Social Security is unconstitutional? And can you imagine if all of those were subject to annual appropriations, what kind of epic train wreck there would be every September when we have divided government? So, I mean, it is, you know, I say there has never been a court that's adopted this argument. After the Fifth Circuit handed down its decision, the Second Circuit didn't follow it at all. I mean, I'm really hopeful that the Supreme Court is going to just, this will be such an outlier that there is a very easy answer here. But, you know, it had to step in because the status quo is right now in the Fifth Circuit, CFPB can't really do much, right? And it's not just the Fifth Circuit. There was a case in Kentucky with respect to small business lending, that a rule there, that's been stopped. I mean, the CFPB can't really do anything right now, and not just in the Fifth Circuit, so it has to resolve this issue. What I fear is that, and we've all seen this movie before, that, it won't, if it's not error correction, the Fifth Circuit was wrong, it's cracking the door open a little bit with some kind of special rule for the CFPB because, fill in the blanks, it's got big enforcement authority, it controls a lot of the, like whatever the new rule is, we'll be back next year with the next case if that door is cracked open. And we'll be talking about OCC or the Fed. And that's the routine. I think we're gonna talk a little bit about Atchison and standing. It's the same, that's the same playbook that we see year after year. So I'm hopeful that this is an easy case. I'm really fearful if the door gets cracked open and we start to see large swaths of the government under attack from those who really want to shrink government down.
Yeah, thank you for that. Folks are seeing a theme clearly, which is we can't regulate industry in favor of climate safety of one kind or another. We can't regulate domestic abusers in favor of gun safety and community safety, and we can't regulate payday lenders in favor of a fair and equitable economy. Deepak, you're going to talk about the last case, which is kind of the flip side of that, which is individuals actually seeking to affirm their rights as they are recognized by government. Could you talk a little bit about Atchison Hotels versus law firm?
Yeah, sure. And I'll just say one quick personal note about the CFPB case, because before I started this firm, I was at the CFPB working with Elizabeth Warren to try to build that agency. And the whole point of that agency was a response to the financial crisis. And the funding mechanism is not just some technicality, right? The reason to do it this way was to prevent the agency from being under the hooks of the financial industry and its political power in Congress. So, it's a really important mechanism for the independence of the agency. And I agree, I think the real question is whether there's a way to distinguish the CFPB, and I really don't think there is. There is no meaningful constitutional distinction between the way that the Federal Reserve Board is funded and the way the CFPB is funded. And so I think this is one example where the Fifth Circuit just kind of is trying it at home and is trying to be like a junior varsity Supreme Court, and no attack on the administrative estate is too crazy, and the Supreme Court has to rein them in. And we're going to see that, I think, repeat itself. So this standing case is really interesting. The Congresswoman who spoke first, she mentioned the shenanigans around the 3A3 creative case, how there was kind of a manufactured case. You may remember this case about the conservative praying football coach who said he was going to go back to his school and then never did. And so you have these kind of manufactured right-wing test cases where there isn't really a person who's injured and harmed and getting into court, and there's a sense that the court is letting that slide. On the flip side, traditional ways of getting into the court that have been accepted for decades are under attack. And this really started in 2016 with this case called Spokio. Then there was a case called TransUnion. These are consumer cases where Congress passes a law. Congress says you can go into court if something happens to you. You can seek remedies against a company. And the court has started to constitutionalize this area, kind of constitutionalize tort reform talking points, as it were. And this case, I got to say, the facts of this, Atchison Hotels versus Laufer case, they're not great facts for those of us who care about access to the courts for the little guy, because it is a person who has filed 600 lawsuits around the country against hotels that she says she doesn't plan to visit. Now, she is really a disabled person, and she's seeking to vindicate rights under the Americans with Disabilities Act that requires hotels to post information online about their accessibility. But I think it's not a very sympathetic case. It kind of plays into conservative fears about cottage industries of litigation. But what's at issue in the case is this longstanding theory of tester standing, which is, if there's a housing complex that's discriminating against African Americans, you can send someone in to see will they give the white person housing and not give the black person housing? And then we know that, there's a pattern of that, and we can sue them over this. And that's an established theory of standing. The Supreme Court recognized it in a case called Havens in 1982. And that precedent is very much under attack in this case. And so I think this is a case, and this is often true in this court. It matters not so much who's going to win. I think the plaintiff is going to lose the case, in my opinion. But it matters a lot how the court decides this case and how broadly they sweep. Because depending on how broadly they sweep, this could affect consumer cases, environmental cases, workers' rights cases, where there's a theory, either a tester theory, even more broadly, a theory that I have a right to information that the law entitles me to. And the Solicitor General's brief, the Biden administration's brief, I think recognizes how this movie is going to end and tries to give the court a soft landing by saying that Ms. Laufer, the plaintiff, she doesn't actually have an injury under the statute under which she's suing, so the court shouldn't even reach the constitutional question. I'm kind of hopeful that that will happen, but otherwise I think this is going to be another iteration in a trend of limiting access to the courts for ordinary people who are trying to assert their rights.
Thanks, Deepak. I think we'll go for 10 more minutes. If you have questions, please pass them to our colleagues. I'm just going to ask 2 quick questions, and then we'll turn it over to the audience. But if you've written one down, our colleagues are collecting.
No, I don't have to write it down.
Oh, you're going to wait just a second. I've got 2 questions, and then we'll turn it over. But if you do have questions and you're going to write them down, clearly this gentleman is going first. But after that, we'll open it back up. So I've heard this, all of you are excellent lawyers, and I've heard it often said that this is a time to avoid the Supreme Court. Sam, you work on climate litigation, which requires a federal approach. I'm curious, how is it that Earthjustice is thinking about this court and approaching these issues? You've not fared well there recently on issues you care about.
We actually won our most recent case in the
Yep.
Supreme Court, 6-3.
Yeah.
Thank you very much. Clean Water Act case,
Yes.
Maui County. So we won that one. That we didn't want them to grant cert, though.
Right.
And we considered that a very, I wouldn't say lucky. It was just not the territory in which we wanted to be fighting. We view the courts remain a very solid place to make change. If I have 200 environmental lawyers working in my organization. If I had 1,000, I could put them all to work filing meritorious, strong cases based on facts, and we wouldn't have any trouble winning those cases and making change. So the courts remain a good place for us to do work. The court is an important forum because it sets out the rules of the road in a lot of the procedures that we work on, and it interprets the statutes that we work with, so it's an important place. We have to be there, and I tell our supporters all the time, there is no choice. You can't abandon the Supreme Court because this is an important place, right? We have to be there litigating every environmental case on these things because the alternative is to simply lose them, and that's bad for everyone. That said, I don't plan on writing a cert petition anytime real soon unless we get one of these Fifth Circuit decisions that's so far out of the pale we sort of have to say, all right, well, we've got to go up on this. I do view a couple of justices as potentially persuadable, but that's only because some of the arguments and the things that are going on right now are so extreme that it's become that they have become in play. Does that answer your question?
It does.
All
It
right.
does. Esther, is there anything you'd like to add on this point? I'm curious in terms of gun reform and gun safety. How is it that you all are thinking about the federal courts as opposed to the state courts and litigation more generally?
Yeah, I mean, particularly with regard to the Supreme Court, the Second Amendment kind of sprang out of the ground in 2008, and there's not a whole lot of law out of the Supreme Court. And the case that I was talking about last year threw everything into a mess. And so right now, when I think about the Supreme Court and my work, I'm really thinking about clarity. I'm thinking about hopefully some corrective action, because the lower courts are really struggling. And it's not just federal courts, state courts are also struggling. And it's not just us sort of inferring that from the mess of decisions that we've gotten in the last year. They're saying it. They're saying it out loud. That the current Supreme Court rule on the Second Amendment is hard to apply. There are unanswered questions. Even Justice Barrett noted that in her concurrence to last year's decision. She mentioned that we don't know which relevant time period in history is the one that we should be looking to. Another unanswered question in the context of Rahimi, The court opened the door to unprecedented societal change. Well, what makes something unprecedented? Is it because domestic violence has been around for a while that, it's not unprecedented societal change? Or we could look at it a different way. Maybe the fact that we're reacting to domestic violence is the fact that society has changed, and that makes it unprecedented. There's a lot of open-ended questions that the Supreme Court, and it makes me nervous to say this, but we really need them to guide the lower courts right now so that we can get some real decisions to work from and understand what kind of legislation is going to survive litigation in the future.
Great. There's one card that I've gotten that I think is an important case that we haven't talked about. Joe, you might, I think earlier you said you might be ready to talk about it, but anyone should take it. This is the Alexander v. South Carolina case. It's another attack on the voting rights. No, not ready for it?
No, we don't do much on voting rights. So,
Yeah. Well, I thought just so folks know, there's yet another challenge to the Voting Rights Act, again, claiming that there was a racial gerrymander. In this case, it's another potentially set of bad facts where Congressman Clyburn's district is right in the heart of what we're trying to make sense of. And so as we talk about what the rights kind of strategy is in terms of advancing fringe legal theories, to Deepak's point, is often taking the worst possible set of facts at this particular moment to advance constitutional reform in a direction that would be the opposite of most of the 20th century. Okay, ready to take questions from the audience. This gentleman.
Whatever happened to the well-regulated militia?
This is the Supreme Court's new reading of the Second Amendment. The individual, as I mentioned, the Second Amendment as an individual right sprang out of the ground in 2008. So, that was the first time that the Supreme Court really interpreted an individual right under the Second Amendment. And one interesting sort of change that's happened recently, or that's sort of, it's been sort of a industry talking point for a while and has now been parroted by the Supreme Court, is the notion of the Second Amendment as this second-class right. And I think in the context of what I was mentioning earlier and all of the changes that have happened to the Constitution and to our society since the Second Amendment's ratification, and even since the 14th Amendment ratification of the Second Amendment against the states, it's hard to imagine that that's really what's happening, right? Like if we're peeling back all of these other rights and advancing the Second Amendment despite them, I find it hard to really agree with the justices when they say that we're treating it as a second-class right.
Thanks. And I'll leave the last question for Deepak as our host. The question was asked here in terms of in terms of legal journalism, or I think really how we think about the court generally, what is it that we're getting right about our analysis of the court, and what is it that we might be getting wrong about it? I took to heart what Sam was saying, that the courts are going to remain a constant battlefield, one that we have to be engaged in order to secure our rights. Otherwise, what are we surrendering to but a series of losses? But I'm curious, how are you thinking about, in terms of how the public should perceive what's happening at the court right now? Again, what are we getting right, and what is it that we should be paying more attention to?
I want to kind of try to end on a hopeful note. I think that, we hear about a small number of really big cases. And those are the cases where kind of everyone kind of knows how they're going to come out, and they're not going to come out well. And so you can kind of get the sense, well, it's all hopeless. Why do you people even do your jobs? Why do you bother? And the reality is it's more complex than that. These are a set of human beings who haven't been there together very long. It's actually the most unpredictable court that it's been in my lifetime. And there are still fights we can win on. And so what we look for, when we're doing this work is, like, where might the law actually be relevant to the outcome of a case? And there's actually a pretty significant chunk of cases where that's true. And you know what? We don't have a choice, because there's only one U.S. Supreme Court. It makes the law for the whole country, and so we can't just give up on it. And that's why the work I think that litigators do is so important, but also the work that Alliance for Justice does is so important, because it's trying to think about the composition of the bench for the future. So I guess the thing I'd say just at the end is don't give up. Don't give up on the court, don't give up on the law, and I can't really improve upon what Jamie Raskin said, but you have to have hope for the future.
Thanks, Deepak. So yeah, please, round of applause for our panelists, Deepak, Esther, Sam, and Joe. And to our co-hosts, Democracy Forward, Earthjustice, and Gupta Wessler for hosting us. The Alliance for Justice, as I said, routinely hosts Holding Court. This has been our Supreme Court preview, and we hope to see you all again soon. There's something? Oh, okay. And we have more food for you in addition to alcohol in case Deepak's final words didn't make you feel better. There's something sweet and something to drink in the back. So thank you again. Really appreciate it.